versus Hamilton.
Please, the court, I would like to reserve 3 minutes for rebuttal, please.
3 minutes, okay.
Colin Riley on behalf of the appellant defendant, Woodbridge Facility, Inc. Your Honors, may I proceed? May it please the court? Okay, sorry. Your Honor, this is a nursing home negligence case involving a 57-year-old plaintiff, Paulette Hamilton, who was at the defendant's nursing home facility for about 16 days, January 2nd of 2020 to January 18th, 2020. Unfortunately, the plaintiff, Ms. Hamilton, had to be admitted to Tampa General Hospital, where she was later diagnosed with sepsis and was in a hospital for about a month. She did fully recover from that infection. She did go on to, she continues to live today. She was a living nursing home plaintiff, which is rare.
Did she recover just within a couple of weeks of this occurring?
Yes, Your Honor. So
there's no ramifications presently, is that right?
Correct, Your Honor. So she was in the hospital for about, I think it ended up being 45 days, but her infection had cleared about 2 weeks into her hospitalization. They had trouble finding a placement for her due to her underlying illnesses. So there's no permanent injury here. There's no even claim for medical bills, past or future. And yet,
when you say permanent injury, do you need a permanent injury? Because I know there's a lot of discussion on whether you need a permanent injury. I guess in auto cases you do, but what about here in this nursing home negligence case? Is that a requirement? If so, what case says that?
no, it is not a requirement. It is something to be considered when coming to the conclusion and the verdict that the jurors ultimately did. But the case law, the way that it's written, does deal with permanency because most of them are auto accident cases, and that is a requirement for recovery in those
But
situations.
you can see that those auto cases don't apply here.
Yes, Your Honor. I can see that a bright line rule does not exist that they have to prove permanent injury. What does exist is plaintiff's claim for future pain and suffering. Plaintiffs claim that this infection somehow continued to bother her or affect her years in advance when it comes to future pain and suffering, when there's been no medical testimony corroborating that. Plaintiff's expert didn't even mention pain and suffering or future care. There was no claim for future medical bills. So that's just one component of the damages that were excessive that I can get into.
There is some testimony from her family members that she had some cognitive issues that she did not have before.
Okay.
Right?
Yes. But I mean, and that kind of leads me into the issue that we're here today. Causation. This case comes down to the causation. How did the nursing home cause Miss Hamilton to get the infection and to get sepsis? And there's been no testimony from any medical experts, from plaintiff's expert, from the defense expert that suggests or even proves that a urinary tract infection caused Miss Hamilton to have sepsis and led to the hospitalization. There's just no proof in the records other than one piece of paper that says the sepsis was due to urinary source.
But sepsis can occur because of urinary tract infections in general.
Yes, that's correct, Your Honor.
Well, your position is we don't know if it occurred specifically in this case, if there was a connection.
Correct. You know, when they go to the hospitals and they have these serious infections, they want to find out. They want to find out what antibiotics work the best for this bacteria. They want to make sure that when they culture everything that they know, you know, where it came from, because that helps with the diagnosis and the treatment.
So if causation was not an issue, what's this case worth?
Nothing, Your Honor. I don't think this case is worth anything because there's no direct line. You can't go from A to B at any point in this case. So the urinary tract infection, there's no conclusive evidence that causes sepsis. Our expert said maybe it was pneumonia, which she also had at the same
Except for
time.
the jury heard the case and they felt there was.
Yeah,
I
Your Honor.
mean, we just throw that out?
Well,
It doesn't matter?
the problem with something like we're dealing with here with infections, we're talking about cultures, we're talking about colony counts, we're talking about symptoms
Well,
and
the
things of
jury
that
also
nature.
heard testimony of just outrageously bad care that she was receiving at the nursing home. And I'm not clear in my mind whether the jury was aware of the falsification of nursing home records. How much did that play in this trial?
Well, and the way that we look at it is documentation is important. But did that cause the injury to Miss Hamilton? I don't think it did. And I don't think there's any statement.
Well, it would certainly predispose a jury to look askance at your client and how they behaved, coupled with the very poor quality treatment, and the fact that they endeavored to falsify records, and the fact that this woman did go through quite an ordeal. Fortunately, she's okay as a result of it. But it wouldn't shock me just for a jury to take all that into consideration and say, you know, we need to stick these people hard. Not only do they treat their patients badly, they don't tell the truth when they're, you know, held accountable. You know, and this lady went through quite an ordeal that she shouldn't have had to go through. So, you know, and that's what I'm not clear about. How much did the jury know about the falsification of the records?
Oh, it was presented. I went to the trial on this case. Mr. Harmon made it known that, you know, he had issues with the documentation. His expert said that there was issues with the documentation. Now, my argument is that Chapter 400.023 is exclusive cause of action for violation of residents' rights or negligence which alleges personal injury. There are ways to make sure that documentation is done the way that it's supposed to do, through ACA, through the regulations and things of that nature. The documentation did not cause a personal injury.
But it calls into question the veracity of your client and the things that they did. And it could cause a jury to say, these people not only don't take care of their patients, they don't really tell the truth when they're, and there may be, rightfully or wrongfully, some punitive aspect of their award.
Well,
And getting to the point about the UTI connection with the sepsis, I know it's your position that she had a pre-existing lung issue that could have also caused sepsis, but I don't believe there was any testimony that that was directly the cause either. It's merely supposition that that could have been the cause.
No, and I completely agree with your take on that, Your Honor, but that's not the defendant's job. The defendant's job is not to prove beyond a reasonable doubt or by clear and convincing evidence that we know where the infection was. The simple truth is nobody does. And that's a plaintiff's burden to prove that this was the cause.
But I guess the jury's verdict, in their mind, the plaintiff carried their burden, which is why they came back with the verdict they did.
Well, and this will lead into the next argument then, that it wasn't dictated by facts. It was dictated by the conduct of the trial attorney for the plaintiff's side. I mean,
We'll go back, let's go
Okay.
back to the.
Yeah.
Okay. On the verdict form, wasn't there something that the jury found, that there were violations by the nursing home, right? I mean, that was one of the check boxes on the verdict form, okay. And so there was also testimony from the plaintiff's expert that, yes, there were violations. And here, you know, she comes to the hospital with the infection. And I think, isn't the point that if the records hadn't been falsified, that she would have gotten the timely and appropriate care that she needed so that she didn't need to go on an emergency basis to the hospital? Isn't that the point? And wasn't that the testimony from, I think it's Dr. Levitel, how do you pronounce that?
that's correct. I mean, I don't think that's accurate reflection of what actually occurred. She had vital signs taken throughout her residency. She had an abnormal vital sign on the day they ended up sending her out to the hospital. Before that, you know, there wasn't any sign or symptom. There wasn't anything that showed that, hey, we should be sending her to the hospital, you know, and maybe that does go back to the records because there were, you know, records for those 2 days, but they're just missing a connection still. What exactly did they do that led to the sepsis if the urinary tract infection that was not the source of it? You know, so we're putting the cart before the horse and we're trying to work backwards from there, but they never really put the...
falsification of records and there's mischarting, then then the jury heard all the evidence and maybe called into question what actually did happen and whether she did timely get the appropriate care she needed.
And I think this is where we disagree as far as plaintiff and defense is that, you know, there's a case called Green that we cited in our, Green versus Llewellyn that we cited in our brief, and that basically this guy had a car accident and then he suddenly couldn't hear and he had a sense of smell was lost too. Now, all they knew was that he could hear and smell before and he couldn't hear and smell after. Well, no layperson is going to be able to make that connection other than, you know, was it the actual cause? Because the doctor came in and said, you know, this competent medical evidence that you need to demonstrate legal causation by expert testimony when it's beyond the common knowledge of laymen. And I think that's what this case is. I mean, even the experts disagreed on whether or not she even had a urinary tract infection. Ours said that the colonization, the number of bacteria in the urinalysis they took wouldn't even have qualified for a UTI because she didn't have the symptoms. And that's in line with the CDC requirements as well that were cited throughout this case.
Yeah, I know you want to talk about the things that occurred that may have inflamed the jury's passions, such as the hand holding between counsel and the victim and things like that. Why don't you go ahead and shift that gear? Because I think you've been anxious to get to that.
Well, I mean, it's just kind of par for the course, right? So we don't have any medical evidence. We have nothing tying the sepsis to the urinary tract infection. So what's the next step? We play on the jurors' emotions. We console a witness that didn't need consoling. She could have cried. She could have taken a break. She could have taken a recess. But no, Mr. Harmon got up, was holding her hands, looking her in the eye, never asked for permission from the judge to approach, and just did it.
Well, she didn't ask permission from the judge to approach, which of course is etiquette and protocol in court, but it's certainly not a reason to reverse this case.
Oh, I understand, but this is just kind of stacking of multiple issues.
And holding the hands of a witness is, I mean, that's fairly benign, it seems to me.
Okay.
I mean, it's not something I would have done. No, and apparently you wouldn't have done it either. But, you know, I don't see that as a reason to reverse this case unless it was extraordinary and extreme. But I mean, the court eventually cut it off, correct?
Right, yes, after we moved to mistry the case. But, and this is just the straws that lead up to breaking the camel's back. Maybe that one instance is not enough to overturn, but then.
So what else you got?
Well, during a sidebar conference, Mr. Harmon's
talking, said they tried to prevent it.
Yeah, and it's just a constant theme of us versus them, of casting the defense as the bad guys without any actual evidence or facts to back that up. And that's what led to this community conscience, which wasn't just stepping on the
I
line.
think the judge said on the record that the jury didn't hear that comment.
He said,
Am I mistaken about
I think he said, I don't think they could hear it.
that? Yeah.
I don't know one way or the other. I was on the opposite side of the court. I can't sit here and tell you whether they heard it or not. I don't think anybody can, to be honest.
I mean, that motion was filed, although it wasn't heard. I mean, it was filed. It's not necessarily a completely untrue comment. There seems to be doubt about whether the jury heard it. So what else you got?
Well, the comment that we didn't call any witnesses to refute the plaintiff's case. I mean, the plaintiff had the same witnesses. They're not even employees of our client. You know, just making it look like we're hiding something again when that's clearly not something to be commented on. You know,
Do you think it poisoned the entire trial?
I don't know. I think the addition of all four of these different acts that were clearly violating rules of
Yeah, the question, of course, is it harmless or is it material? Would it change the outcome? And that's always the question we wrestle with, you know.
Yeah, I mean, it's hard to tell, right? You can't get into the jurors' heads. I don't know if one of these or any of these led to the jurors coming to their conclusion.
But you also have that comment in closing about, send a message to them that they can't treat our elderly this way. You were concerned about that, but you didn't object to that either.
Well, you know, there's a case that says that if it's so egregious, you know, and we bring it up later on, as we did in the motion for directed verdict, or I'm sorry, the the JNOV motion post-trial, then that's enough to overcome when it's so inflaming that we are able to bring it up on appeal. But it wasn't even close to, you should do this, or it was very forceful. It was basically, you mentioned it yourself when you're saying it was punitive. This is not a punitive damage case. This is a case about compensatory damages.
I didn't use that word in a technical sense.
I understand, and that's why I didn't jump on it, but
As an explanation of what they might have had in their mind.
I understand. But I mean, I was gonna get there anyway, because, you know, that is a
Don't you think juries
punitive.
do that from time to time?
Of course they do,
Yeah.
but that
That's
doesn't.
why it gets higher, because they may not necessarily be imposing a measure of punitive damages. They decided that they don't like a party because they weren't honest or forthcoming, and, they didn't like the facts, and that has a tendency to elevate verdicts.
I agree, and the jurors have that right, but what the parties don't have a right to is to inflame those thoughts, to inflame that this is a punitive damage case when it's not. They have a higher burden to meet a punitive damage case, and instead they just say, oh, it's your job, it's your duty to send a message. Well, I don't know what other euphemisms you can use for punitive damages, but that's basically it. You know, he said, send a message, tell them we don't do this. Basically tell them never to do this again. That's moving forward. That's not moving in the past for compensating somebody for their
See, the
injury.
struggle we always have here on this court is whether something is so bad that it tainted the whole trial and we need to reverse, or whether to not do that and maybe send the wrong message to the bar that says you can get away with this stuff. So it's a fine line that we walk to try to, to look at this.
Well, I mean, there was a case called Gladman that we cited as well, in which,
Just so you know, you have 30 seconds left until you're at your 3 minutes.
okay.
But it's your time. You can do anything you want to with it.
Okay, well, the last thing we kind of been touching on that really is tying it all together, the damages. I mean, the plaintiff asked for $1 million for past pain and suffering.
Didn't they
And future
didn't they
pain,
actually say, though, don't return a verdict for less than?
Yes,
It's not the same as asking. They're just saying, we expect at least that. It's not the same as saying we only want that, right?
sure. I mean, I mean, I guess if you want to get real technical, yes, but I think it's an ask for what he thought this case was valued at.
Thank you. You've got 3 minutes left when you come back.
May it please the court, Catherine Lee representing appellee Paulette Hamilton through her daughter DeQuesta Allen.
$2.5 million is a lot of money
It is. The
for
jury
no
gave-
permanent damages and no future medicals and all that.
Well, you don't have to have economic damages to have non-economic damages under Florida law. And that was the plaintiff's choice not to present those claims. But what it was the jury awarded $1.5 million for almost killing her and putting her in the hospital, 16 days of neglect, 4 days in ICU, 40 days in the hospital, 1.5 for that.
But you also
1
heard
million.
there's no direct medical connection between the UTI and the sepsis.
I would love to address the causation issue. First, let's look at what the jury instruction is, what we would have to prove. And it is a violation of nursing home residents' rights or negligence on the part of defendant that was a legal cause of injury to Ms. Hamilton. There was injury. She spent time in the hospital. She had a UTI. She went into sepsis. The sepsis, as cultured by TGH, was, I'm going to mess the word up, Proteus mirabilis. My Latin teacher would be so mad at me.
Better job than I would.
That is from fecal contamination. So what the jury heard was neglect. Whole time, 16 days. She was taken to the toilet once. Her diaper was changed twice. She was taking off her own dirty diapers and throwing them on the floor. The first signs of UTI, which was confusion and a fever of 103, came out on January 9th. She wasn't sent to the hospital until January 7th. And that's when the false charting started. They were recording The nurses were recording normal vitals. The PT and the occupational therapist were recording that she was confused and unable to participate. Now, Dr. Locatell did explain how this neglect created the sepsis. She did talk about how it's a cascade, it's a progression, that the longer you take to get antibiotics, the worse it is. So what we have here was the first time she presented with a sign of a UTI, January 9th, they said, go get a urinalysis. They didn't even take the sample until January 11th. The sample might not have come back as something that they should have had antibiotics for, but if they had been recording her vital signs and watching her closely for confusion, which is a sign of infection, they would have known that there was something more wrong. And it wasn't until her daughter came in and said, my mom is hallucinating. Something's wrong. Get this done. Then they got the full culture back, and the full culture showed she was flat out, had a UTI. And they gave her antibiotics. The next day, daughter called again. My mom is bad. Please get blood work. They get the blood work. It shows she is in renal failure and kidney function is failing. And Dr. Locatell explained how at each step, each delay in treatment was a violation of her rights. Dr. Locatell also explained how the night the blood work was taken, the family called in and said, what's up? What's up with mom? They were told, came back normal. The next morning, she is in full-on sepsis. The doctor called the facility and said, get her to TGH. They waited 2 hours before they even called an ambulance. And when the ambulance showed up, she was completely non-responsive with a Glasgow Coma scale of 7, which is normal is 15. That is not good. So the jury did hear significant evidence of violations of rights and how that neglect caused sepsis. Dr. Locatell completely eliminated other sources of infection. There were nothing in the record that showed infection with Proteus M.
Pre-existing lung condition?
Different infective source. So at TGH, they knew it was from fecal contamination that caused the injury. And trying to get back to where I was going, I'm sorry. The other thing is the false charting. Dr. Locatell did testify repeatedly about how those things are a violation of rights of the resident. Now, the false charting, we know it was false charting. They were recording normal heart rate, normal everything. The nurses' notes were. When they recorded them, there were days with no notes. Conflicted with what we learned later at TGH, because Ms. Hamilton had an implanted pacemaker that recorded her heart rate. And showed that days before she ever even got antibiotics, she was in full-on sepsis with severe tachycardia events, hundreds of them, with heart rates of up to 300. So that's the jury heard, here's this medical evidence that TGH put together, here's what the chart at the hospital or at the nursing home said. And the jury was allowed to put that together and do what they want to decide if there was a violation of rights or negligence that caused injury. So there was evidence of causation from which a jury could have returned a verdict. There was also evidence of both past pain and suffering and future pain and suffering. This is not something where you have to have expert testimony. Often the only testimony about the loss of enjoyment of life that constitutes non-economic damages comes from the plaintiff and their family themselves. And that's what the jury heard in this case. The jury heard her daughter, she's much more forgetful, much more fearful, much more scared, has nightmares, wakes up all the time. Ms. Hamilton herself testified about the nightmares, about her memory problems, how living with this every day. She had a near-death experience caused by neglect, and she lives with that every day. And she explained how that haunts her and how she worries about everybody who's in that facility. That is a permanent thing. It doesn't have to meet the permanency threshold of the PIP statute. We don't have to have that. We don't have to have medical evidence to prove that. You tell the jury what you're experiencing, and they decide if that is ongoing and worthy of future
In
damages.
essence, at closing, yeah, your counsel, it wasn't you, was it? It was.
No, sir, it was not me.
Somebody else, yeah. They basically, I mean, your opponent said they only asked for $1 million.
He said, not one penny less than.
I know, but that really sounds like $1 million. I am sure that even that lawyer was surprised when they came back for 2.5 million.
During closing, he also said, if this was a death case, I would be asking you for 3 to 5. Those words are in the transcript. He said, if she had died, I would have been asking you for a lot more money. So Mr. Harmon, trial counsel, telegraphed he wants somewhere between 1 and 5. Where did they land? 2.5.
But there are things that happened in the trial that arguably inflamed the passions of the jury. And you've heard, I mean, you well know them, they're in the briefs and all that, and you've heard them argued again. What about those things? Not just individually, but collectively, including the plea to the jury to, the community plea to stop this type of behavior, send a message.
Of those 4 things raised, only one of them represents any actual impropriety, and that is the conscience of the community argument. However, it was unobjected to at trial, which puts us into fundamental error, where it had to so damage the fairness of the trial that the interests of justice and public faith in the system require us to fix that. That one short comment of hold them responsible does not rise to the level of fundamental error, and repeatedly has not in many other cases, especially because during defense closing, they made a point of explaining to the jury, do not rule on sympathy. Use the evidence, do not allow this to influence your decision. But had it been so offensive, it should have been objected to. They objected to other things during closing. They knew how to, they just didn't. So overall, it was a short blip in the trial that did not affect the whole outcome. The verdict was not the product of the hold them responsible. It was a product of hearing of 16 days of neglect, utter indignities to a woman who was supposed to be cared for by this facility. That's what caused the verdict, not the hold them responsible for it. Is there a particular other incident you would prefer me address first?
I think you've kind of hit the general issues, unless you got something special you want to tell us.
And if you have no questions, I will stand on my briefs. Thank you, Your Honor.
Thank you very much. You have 3 minutes.
Well, just again, to tie this all up in a bow, there's just no there. There's no connection between the conduct that they're claiming occurred with defendant that led to the UTI that then led to sepsis. There's no argument, there's no straight line that gets there. And during the COVID-19 crisis, a new statute came out. They said, if you're going to say an infection occurred somewhere, you have to have the whys, the whens, the hows. You have to plead that with particularity. The same kind of standard should be true with all infection types of cases. We don't know where this infection came from. Nobody can sit here and look you in the eye and say, I know this was from the urinary tract infection, and that was due to the neglect of the nursing home staff. It's never been in any record. And in fact, Ms. Locatel, when pinned down, admitted that she could not tell you the source of that infection within a reasonable degree of medical probability. And that's a standard we have to operate on. That's above 50%. It's not a high standard. She couldn't even reach that. And so when we're dealing with medical cases like this, it is important to rely on experts. I can't sit here and tell you what a urinary tract infection is, and I don't think 6 jurors can either. What they have to do is rely on the experts to tell them whether or not that's true. And in this case, that never happened. And so they came to a conclusion that wasn't supported by evidence. And the only conclusion I can get from that is that it was inflamed by all these different tactics from Mr. Harmon, It was done because they don't have a case. They don't have a case pointing from A to B. And, you know, simply put, it should be remanded to a new trial. It should be addressed specifically as what actions did we take that led to urinary tract infection, or what other source of sepsis, and then sepsis in our hospital. This isn't strict liability. People go and get sent to the hospital quite often for things that are unrelated to the nursing home staff. And that's what happened with Miss Hamilton here. You know, any claims of future damages for nightmares, $1 million for nightmares, $1 million because the daughter says that she can't remember things very well when she had major issues prior to this, including a stroke. So if we're going to let the lay people be the experts in this case, and I can understand that that's how they came to that conclusion, but the medical support isn't there, the medical evidence isn't there, and I think in a case such as this, when you're dealing with infections, that's a requirement, and that burden was never met. That's it. Thank you.
Thank you. You both did a nice job today. I appreciate your briefs and your presentations, and you helped us with this